The Supreme Court just dropped an emergency ruling that could eliminate firearm permits across America. Right now, millions of gun owners are being forced to beg the government for permission to exercise a constitutional right. But that could be ending soon. And if you want to stay ahead of what could be the most important gun rights case in modern history, hit that subscribe button right now, because things are moving fast, and most people have no idea this is even happening. Here's why this moment is different. The Supreme Court's emergency intervention in this permit case marks only the third time in Second Amendment history that the justices have bypassed normal procedures to hear a gun rights challenge. Let that sink in. Emergency petitions to the Supreme Court get denied 99% of the time. Out of every 100 urgent requests, only one gets through. But the justices saw something in this case that demanded immediate action. And in the speed is what should tell you how serious this is. From the initial filing to granted review took just 47 days. Compare that to the typical timeline for regular cases, 8 to 12 months. We're talking about a process that normally crawls, suddenly moving at lightning speed. 4 justices had to vote yes for this emergency review, which means there's already substantial support on the court for addressing permit requirements head-on. The oral arguments are scheduled in just weeks, not months. And legal experts are predicting we could see a decision within 60 to 90 days, not waiting until June like most Supreme Court cases. The court's clerk office has already started clearing the calendar for what insiders are calling a major constitutional announcement. Supreme Court historians are saying this kind of expedited timeline has only been used before for cases involving fundamental rights violations affecting millions of Americans. And here's the part that makes people think this could go big. The justices requested supplemental briefing on whether their ruling should apply retroactively. That means they're considering a decision, so sweeping it could potentially invalidate decades of convictions under permit laws. Think about that. They're not just asking, are permits okay? They're asking, should we undo all the damage permits have caused? Now let me tell you why the court suddenly decided to act now, because the numbers are staggering. Currently, 23 million Americans live in states that require permits just to purchase a handgun. That's not even counting the additional 87 million people living in states with carry permit requirements. We're talking about over 100 million Americans whose Second Amendment rights are being treated like privileges the government can hand out or take away. And these aren't criminals, these aren't prohibited persons, these are law-abiding citizens who have to pay an average of $340 in fees, wait an average of 94 days, and complete an average of 16 hours of mandatory training before the government might grant them permission to exercise a constitutional right. In New Jersey alone, the average wait time for a purchase permit is 127 days. In Maryland, applicants report waiting up to 6 months. During the pandemic, some states completely stopped processing permits, leaving thousands of Americans defenseless, while crime rates spiked 30% in major cities. One applicant in Massachusetts waited 14 months, over a year, only to be denied without any explanation. These aren't just statistics on a page. These are real people being denied their rights every single day. And it gets worse. Some jurisdictions have been caught deliberately slow-walking applications for people they don't like, based on political beliefs or social media posts. Civil rights attorneys have documented over 2,400 cases where permits were denied to fully qualified applicants with no legitimate reason given. The backlog in some places has grown so bad that people who filed applications in 2023 still haven't received responses. That's a permanent denial through bureaucratic delay. But here's the part that should make every American angry, whether you own a gun or not: how much money states are making from these schemes. State and local governments collected $847 million in permit fees last year alone. That's not a typo. Nearly $1 billion extracted from citizens for the so-called privilege of exercising a constitutional right. California brought in $143 million. New York collected $89 million. Illinois pulled in $67 million. And here's the kicker. These fees aren't even going toward public safety or crime prevention. A 2023 audit in New York found that only 14% of permit fee revenue was actually used for background check processing. The rest went into general revenue funds. It's basically a tax on constitutional rights. Some jurisdictions charge $500 or more just for the application, and that's before mandatory training courses that can cost another $300 to $400. For low-income Americans, these fees are flat-out prohibitive. A single mother working 2 jobs can't afford $800 and take 2 days off work for training just to be able to protect herself and her kids. This creates a 2-tier system where wealthy people can exercise their rights, while poor people cannot. And financial analysts have calculated that if permits are struck down, these states will lose nearly $1 billion annually in what amounts to unconstitutional taxation. Budget documents from restrictive states show they've become financially dependent on permit fees, treating constitutional rights as a revenue stream instead of protecting citizen freedoms. Freedom of Information Act requests revealed that certain cities actually budgeted for permit revenue increases before even announcing fee hikes. They're treating gun owners like a captive revenue source. So let me ask you this. Should constitutional rights only be available to people who can afford to pay the government for permission? Now here's where the legal firepower comes in. The Trump Department of Justice didn't just file a basic legal brief in support of striking down permits. They submitted a 487-page amicus brief with 1,243 historical citations, proving that permit requirements have zero foundation in American legal tradition. Their research team spent 3 months digging through colonial records, founding-era state laws, and early court decisions. And what they found completely destroys the argument that permits are somehow consistent with historical tradition. Not a single colony required permits for firearms. Not one. Not a single founding-era state constitution mentioned government licensing for arms. The first permit requirement didn't even appear until 1911, 120 years after the Second Amendment was ratified. And that 1911 New York law, it was explicitly designed to keep firearms away from immigrants and minorities, not to promote public safety. The DOJ's brief includes actual quotes from legislators at the time admitting the law's discriminatory purpose in their own words. This historical evidence is so overwhelming that even some liberal legal scholars have quietly admitted that permit requirements can't survive serious constitutional scrutiny under the test the Supreme Court laid out in the Bruen decision. The brief even uncovered evidence that early Americans would have viewed permit schemes as just as tyrannical as requiring government approval before you could speak or practice your religion. Documents show that founding-era Americans believed requiring permission to bear arms was fundamentally incompatible with the concept of individual liberty and natural rights. But there's one piece of evidence the opposition really doesn't want the court to see, and it's the strongest proof of all. 29 states have now eliminated permit requirements and adopted constitutional carry. That's 29 real-world experiments proving that permits are completely unnecessary for public safety, and the results are undeniable. After these states eliminated permits, violent crime didn't increase. In fact, 18 of those 29 states saw violent crime rates actually drop in the 2 years following constitutional carry adoption. Texas eliminated their carry permit requirement in 2021. Gun control advocates predicted bloodshed and chaos in the streets. Instead, violent crime in Texas dropped 4.3% the following year. Florida went constitutional carry in 2023. Opponents said murder rates would skyrocket. Instead, murder rates fell 7.1% in just the first 6 months. Ohio eliminated permits in 2022 and saw a 5.8% reduction in violent crime over the next 18 months. Meanwhile, states that kept their strict permit requirements, they saw crime rates increase. New York's violent crime rate jumped 11.2% despite their extensive permit system. California saw an 8.9% increase. The data is crystal clear. Permits don't make anyone safer. They just prevent law-abiding people from being able to defend themselves. And here's what should end the debate. Independent criminologists who initially opposed constitutional carry have now published studies admitting their predictions of increased violence were completely wrong. Police chiefs in constitutional carry states report the transition created no enforcement challenges and actually improved community relations. Even insurance industry data shows that constitutional carry states have seen stable or declining rates of gun-related insurance claims, contradicting all the predictions of increased accidents and liability. But the evidence doesn't stop there, because after constitutional carry states eliminated permits, something interesting happened in the states next door. Applications in neighboring restrictive states dropped by 340,000 year over year. That's 340,000 people who either moved or just gave up on the unconstitutional permit process. Illinois lost 47,000 FOID card renewals after neighboring Indiana, Missouri, and Iowa went constitutional carry. Maryland saw a 31% drop in applications after Virginia simplified their process. This represents hundreds of thousands of Americans who basically said, forget it, the barriers are too high. And these states are now losing serious tax revenue and population to constitutional carry states. Texas gained 1.7 million new residents in the past 3 years, with many citing gun rights as a factor in their decision to move. Florida added 890,000 new residents. Meanwhile, New York lost 523,000 residents, and California lost 817,000. The economic impact is staggering. Restrictive states are losing billions in tax revenue while constitutional carry states are booming. Business surveys show that 34% of companies relocating to southern states cited gun-friendly laws as a factor. Real estate data shows property values in constitutional carry states have appreciated 12% faster than permit-required states over the past 5 years. Moving companies report a 67% increase in relocation requests from restrictive states to constitutional carry states since 2020, with gun rights consistently mentioned as a primary reason. Economic development offices in constitutional carry states have actually started advertising their gun-friendly laws and recruitment materials, successfully attracting businesses and workers from restrictive states. So here's my question. If permits actually made states safer, wouldn't people be fleeing constitutional carry states instead of flocking to them? Now, here's where things get frustrating. The Supreme Court ruled in Bruen just 2.5 years ago that gun laws must be consistent with historical tradition. The decision was crystal clear. States cannot impose restrictions that didn't exist when the Second Amendment was ratified unless they can point to similar historical regulations. Yet 14 states completely ignored that ruling and either kept or even expanded their permit requirements. New York responded to Bruen by making their permit process even more restrictive, adding new fees and training requirements. California passed laws requiring psychological evaluations for permit applicants. Hawaii created a default ban on private property that sparked yet another lawsuit. These states looked at a Supreme Court decision and essentially said, "We don't care." Federal judges in the Ninth Circuit have been openly hostile to Bruen, with one judge literally writing that the Supreme Court's Second Amendment jurisprudence is wrong-headed and dangerous. Constitutional scholars have identified 63 separate instances where state courts misapplied or flat-out ignored Bruen's clear test. Lower court judges have admitted in published opinions that they disagree with Bruen and are interpreting it as narrowly as possible to preserve gun control laws. Legal tracking organizations documented that appellate courts have upheld gun restrictions in 78% of post-Bruen cases by creatively reinterpreting what counts as historical tradition, effectively ignoring the Supreme Court's order. This open defiance is exactly why the Supreme Court had to take this emergency case. Because if they don't enforce their own rulings, the entire system breaks down. And that leads to what's happening behind the scenes at the court itself. Court watchers have noticed unusual patterns. Between June 2023 and December 2024, the court received 47 emergency gun rights petitions and denied all of them. Then suddenly, they granted this one. Legal analysts believe the shift came from Justice Barrett, who reportedly grew frustrated with states openly ignoring Bruen. During a November oral argument in an unrelated case, she made pointed comments about lower courts slow-walking constitutional rights. Sources familiar with court discussions say Justice Gorsuch has been pushing aggressively for the court to hear more Second Amendment cases and stop letting states ignore their orders. Even Chief Justice Roberts, who's typically cautious about controversial cases, allegedly supported emergency review here because of the blatant defiance from multiple states. The fact that the court allowed the DOJ to participate in oral arguments is also telling. They rarely let the executive branch join cases where the federal government isn't directly involved. This suggests the justices want to hear the strongest possible arguments on both sides before issuing what could be a landmark ruling. Legal insiders report that Justice Thomas has been privately circulating draft opinions on Second Amendment issues, suggesting he's prepared to write a sweeping majority decision. Court employees have noted an unusual number of late-night research sessions in the court's library. Clerks working on this case have been given extended research time and access to rare historical documents normally reserved for only the most important cases in Supreme Court history. Behind-the-scenes negotiations suggest the conservative justices are working to craft an opinion so legally airtight that lower courts will have no choice but to comply this time. So what happens if the Supreme Court rules that permit requirements are unconstitutional? Legal experts estimate that within 72 hours of such a ruling, lawsuits would be filed challenging permit schemes in every remaining restrictive state. State attorneys general and constitutional carry states have already prepared template lawsuits ready to go on behalf of their residents who work or travel in permit states. Gun rights legal organizations have identified 127 specific state and local laws that would immediately become vulnerable using the same reasoning that strikes down permits. This includes waiting periods, purchase limits, approved handgun rosters, and mandatory training requirements. We're talking about the potential invalidation of thousands of gun control regulations across the country within months of the decision. Registration requirements could fall. The entire regulatory system that gun control states have built over decades could come crashing down. Constitutional law professors are already calling this the potential Roe v. Wade moment for the Second Amendment. Legal defense funds have raised over $47 million, specifically to challenge gun laws immediately following a favorable Supreme Court ruling. Second Amendment advocacy groups have established rapid response legal teams in all 50 states, ready to file coordinated lawsuits the moment the decision drops. The question isn't whether this will cause massive legal change. The question is whether America is finally ready to restore constitutional rights that should never have been restricted in the first place. So let me ask you one final question, and I want you to answer in the comments. Are you ready for constitutional carry to become the law of the land nationwide? That's everything happening right now in this groundbreaking Supreme Court case that could end permit requirements from coast to coast. Make sure you're subscribed because oral arguments are happening soon and we'll break down every major development as it unfolds. Drop a comment and let me know, do you think the court will rule in our favor, or will states find another way to ignore the Constitution? Hit like, share this with every gun owner you know, and I'll see you in the next one.